So today I'd like to talk about asset protection and how it is involved with estate planning. Most people, when they think about estate planning, are thinking about leaving their property to the right people at the right time with proper restrictions. They're thinking about maybe avoiding taxes. But another big component of good estate planning is asset protection. Protecting your assets from creditors so that you have those assets to pass on ultimately to your heirs. Today I'd like to talk about the top 10 tips for asset protection in estate planning. Number one is to avoid a fraudulent conveyance. This really is the number one rule. This type of asset protection we're going to talk about today doesn't start after you've been served with a lawsuit. It starts hopefully years in advance of that. So a fraudulent conveyance is a conveyance that's where you're transferring your property in a manner that's there to defraud creditors. And that's a no-no. Civil fine, or there's criminal penalties that can be involved, all kinds of things can go wrong. So number one, we want to avoid those fraudulent conveyances. Number two is to have proper insurance. So here we're talking about property and casualty insurance, we're talking about liability umbrella policies, we're talking about proper malpractice insurance for those professionals out there. But having the right carriers, the right coverages, the right amounts in place, all are going to ensure that first line of defense that if you are sued, the insurance is going to step in to help protect those assets that you've worked hard to build up. Number three is reviewing how your property is titled. In many jurisdictions, if you're married, there is a way that husband and wife can own property called tenancy by the entireties. A tenancy by the entireties can protect those assets from creditors of just one spouse. So if I'm married and I'm sued individually, my wife is not named, if I've got property as tenants by the entireties, that property can be protected from my creditors. Also, if one spouse has greater liability exposure than the other, often housing assets in the spouse without that liability exposure might protect them. So it's important that all of your assets are looked at to see how are they owned, how are they set up, and are there ways we can title them to offer greater protection. Number four is to use gifting. This includes outright gifts to children and other family members. It could include gifts to trusts, such as irrevocable trusts, or gifts to family LLCs. This is a way for you to transfer property out of your name, but into names of other family members so that that property can be protected if later on you get sued or have liability exposure. Number five on the list is utilizing exempt assets. These are assets that, through their very nature, have protection from creditors. Examples of this are retirement plans, such as IRAs and 401ks. Also, in some jurisdictions, life insurance and annuities have protection. This is a way where you can park your assets in places where if you are later sued, there is protection from creditors, and those creditors can't reach those assets such as IRAs or 401ks. Number six is the use of entities. Creating limited liability companies or other corporate forms and then housing assets inside of those can work to help protect your assets in two ways. Number one, they could, if a liability exposure comes out of the business activity in that entity can trap those liabilities and protect them from spilling over into your other personal assets. In addition, by having assets owned by limited liability companies, this can protect against your creditors from getting to the underlying assets that are inside of those entities. So utilizing an entity like an LLC is another way we can protect. Number seven is something called equity stripping. This is where you would utilize borrowing against assets and then having whoever the lender is place a lien against those assets to reduce their exposure to your creditors. So for instance, if I have a business that has a number of accounts receivables, if I borrow against those accounts receivable and then now the bank or other lender has placed a lien on those, that protects that interest, that asset, because now they have to a creditor has to step behind that lender to try to reach those assets. Number eight on the list is something called a domestic asset protection trust. Many states, such as Michigan and Ohio, have domestic asset protection trusts where you can create a trust, transfer your assets into that trust, still have access to those assets, but it can prevent your creditors from being able to reach them. Now these types of trusts are fairly sophisticated. They have to be set up properly and again, well in advance of any creditor problems. but this is a way where you can create a trust yourself, transfer assets into it, and if set up properly, those assets can be protected from creditors in the future. One step above that, number 9, is utilizing offshore asset protection trusts or LLC, offshore LLCs. Using offshore entities provides a little higher level of protection versus those domestic trusts, but it also involves a lot more expense and often complexity. So that is something to consider, but it does take your money, just as it sounds, offshore. So the money won't be here. You're going to have a foreign trustee over those assets, but it will offer greater protection perhaps than a domestic asset protection trust. Finally, number 10, assembling the right team of advisors to help you putting into place your asset protection plan. Having attorneys that understand bankruptcy law, creditors' rights, and trust law is essential to having a good asset protection plan built into your estate plan. Thanks for watching.